and 20 minutes for Tidewell.
Okay, so Mr. Smith and Miss George, I'll let you know when your 10 minutes are up, okay?
And if it's possible, Your Honor, I'd like to reserve maybe 2 minutes of my time for any rebuttal on cross appeal.
But for cross appeal, sure. Okay.
Thank you.
Mr. Frayne, if you are ready to proceed, let's go.
Thank you, Your Honor. My name, may it please the court, my name is Jeff Frayne. I am the attorney for the appellant Tidewell Hospice, Inc. I would like to reserve 5 minutes for rebuttal.
All right.
This is an administrative case that was initiated when Tidewell, the existing hospice provider in Sarasota County, challenged the agency's decision to grant a certificate of need for a second hospice program in that county, where the published need was 0 and the application had alleged no special circumstances as defined by the hospice rule itself. An administrative law judge was assigned to conduct a hearing, and he in fact conducted a 2-week evidentiary hearing. Following that hearing, he issued a recommended order of denial. In that recommended order, he found there was no numeric need pursuant to the need calculation, and that there was therefore a rebuttable presumption of no need. He then found that the applicant had failed to rebut that presumption by failing to show special circumstances under paragraph 4D of the hospice rule. Now, 4D of the hospice rule states that regardless of numeric need shown under the, in the absence of numeric need identified in paragraph 4A, which is the need formula, the applicant must demonstrate that circumstances exist to justify the approval of a new hospice. Evidence submitted by the applicant must document one or more of the following. Either got to demonstrate a specifically terminally ill population is not being served, or that a county or counties within that service area of the licensed hospice program are not being served. Now, with respect to those special circumstances, the applicant, the administrative law judge, found that the applicant had failed to show an unserved population within the service area. With respect to the second special circumstance, an unserved county, the administrative law judge determined that was inapplicable. Presumably that was because the applicant had not raised that particular special circumstance in its application, and it was not argued at the final hearing. However, relevant to that, the administrative law judge did find that there was no problem with hospice access or availability within the service area. Now, in the final order, the agency rejected that recommendation. In doing that, in the final order, the agency indicated it did agree with the administrative law judge's interpretation of 4D of the hospice rule. That is, when there is no need, the applicant must show special circumstances.
Can I pause you there just for a second, Mr. Frayne, because there's kind of some first principle issues that have been troubling me in reading through this, and I'd like your thoughts on it. I think it's an issue you broached in your briefing. Rule 59C-1.0355 sub 4 of the Administrative Code provides the numeric formula that you've been discussing, correct? That is how the formula is computed. Am I right?
That is correct, Your Honor.
Okay. Florida statute section 408.043 sub 1 states the formula on which the certificate of need is based shall discourage regional monopolies and promote competition. Okay. Where in Rule 59C.10355 sub 4, the numeric, do I find even the words from competition or monopoly? Are those considered at all in the actual numeric formula?
Your Honor, it presumptively does, because the agency said you shall adopt a formula that discourages regional monopolies. So here we have,
we have a numeric formula My discrete question is, where in that 59C 10355 sub 4 formula, which I think you're right, that is the numeric formula, where in the formula is the vector of monopoly, lack of competition?
Well, Your Honor, I think the way it addresses it is because health planning is normally done on a district level for certificate of needs. In section 408.032, they define 11 health planning service areas, and those are rather large regions. So I think the way the formula discourages regional monopolies is because they have divided those large districts, 11 of them, into smaller service areas. So it prevents monopolies, or at least discourages monopolies, by creating subsets in which need is evaluated. And as a result of that, it really makes it less likely that you will have one provider serving the entire district, which is how need is evaluated for other services. For instance, open heart surgery would be evaluated looking at the entire district. So they've carved it into smaller service areas and evaluated need on that basis. And I think by focusing on that, that's the way that
that seems counterintuitive. I'm sorry, that just actually seems counterintuitive to me, because if you shrink the market, you're more likely to have less competition and more monopolistic tendencies if you draw the box small, right?
Yeah, but the service areas are not large enough to be regions. The only potential region you could have would be the district. District 8, for instance, is carved up into 4 service areas. And as a result of that, Tidewell does not serve all of District 8. It only serves 2 of the service areas within 2 of the 4 service areas. So it is not a monopoly within all of District 8. It also has a service area in District 6, service area 6C, and there are multiple service areas within 6. So it only serves one of those service areas. It is not a monopoly in either service area 6 or in District 6. And, you know, besides, the goal is to discourage, it's not to prohibit. And if you look, the evidence is, if you look over time, there's actually been fewer and fewer hospices that are in serve one county to the exclusion of any other providers. So, but if the applicant had thought that the formula wasn't doing the job of discouraging regional monopolies, there's a mechanism under 12056 for challenging that formula. And
right. My concern in raising that is because the argument is being made what everyone keeps characterizing as a rebuttable presumption, although I don't see the words rebuttable or presumption established in the applicable rule or the statute, but what everybody's calling a rebuttable presumption seems to take into account, at least in Rule 59C.103553B, consideration of whether or not we have a monopoly within a service area or whether or not there's decreased competition. And that does seem to be a valid factor for the agency to consider, doesn't it?
Your Honor, I would disagree with that. I think the statute is very clear. The statute says need should be evaluated based on the need for and availability of hospices within the service area. The second sentence says the formula shall discourage regional monopolies.
Yes.
You would have to rewrite the statute to turn that into a statutory review criteria. But I would also point to the fact that even if you look at the case that's relied on by the applicant, the compassionate care opinion out of the first DCA, even that decision did not describe the existence of a regional monopoly as a not normal circumstance. At most, it would be a review criteria. And there is evidence that was presented by the applicant in this case through an economist is that hospice services are delivered on a local level. If you're in one county, it's irrelevant what is available in another county. Hospice services really aren't delivered on a regional level. It's delivered on a local level. And the applicant in this case didn't propose to serve any of the other service areas that Tidewell is serving. So those other areas aren't even really relevant to the issues in this case. And on top of that, the agency, neither the agency nor the administrative law judge found that Tidewell was a regional monopoly. But let's just take the situation of being a monopoly. And is a monopoly itself, or being a sole provider in a county, some sort of a not normal circumstance? If you look at how the cases have defined what a not normal circumstance is, which frankly, the words don't appear on the face of the hospice rule. You know, you would have to read into the hospice rule a not normal exception.
I think you would have to, I mean, I think you go back to the organic source of lawful power for the agency to even adopt these rules, which is the legislation. And the legislative mandate is that the agency is supposed to adopt a formula that discourages regional monopoly. I don't know how you can read that out of the legislative directive to the agency to adopt a formula that takes that into consideration through the fiat of administrative rulemaking. That what you're trying to tell me is, well, we really, that doesn't even arise to a not normal circumstance. I don't know how you can do that consistent with the legislative mandate.
Well, Your Honor, the way I would answer is the Florida Supreme Court in Goodman versus FDLE 238 Southern 3rd 102 has stated that duly promulgated agency rules are presumptively valid until invalidated. It cited a first DCA case, City of Palm Bay versus Department of Transportation, which it was quoting, and the end of that quote was, until invalidated in a section 12056 rule challenge.
And Mr. Fran, if I'm not being clear, I apologize. I am not suggesting that, you know, the issue of the validity of the rule is not before us. That's not what I'm suggesting. But the legislative language of 408.0431 is, and I can't just simply ignore that language in trying to construe the importance of regional monopoly and competitive effects. I just can't. Or I mean, at least I need help. Tell me how I can put that aside and not worry about it, and come to the conclusion that what appears to me to be a consideration that the agency ultimately made, which is, besides the fact, you know, besides that there is apparently some percentage of folks that are having to leave Sarasota or having to be treated outside of Sarasota County, there's also a concern by the agency that there is a Tidewell has a monopoly, and that seems to be the minority of counties, the situation of the minority of counties within Florida. How can I relegate that statute and say that's not a concern under what we have to work with here?
Well, I think the context that you have to put it in, and let's put aside the fact that there was no finding of being a regional monopoly. There's no definition of what a region is for purposes. You know, if we use the definition of a district, we're not a regional monopoly because we're not the only provider at the district level, either district that we're located in. If you put that aside, the precedent is pretty clear that what the concern is when you're balancing the criteria is when you have a published need, the case law says that does create a presumption of no need. And there's no dispute by any of the parties that there is that presumption. And even if you look at different exceptions outside of the hospice rule, there's other rules have what's called a not normal exception, which is fairly broad, at least in the wording. A monopoly has never been found to be a not normal circumstance in any case. Absent.
Didn't the ALJ find that Tidewell's status as the only provider of hospital services in Sarasota County is not normal?
He did, Your Honor. This is the only case where that was found. but it doesn't fit within how the case law has defined a not normal circumstance. It's not defined in agency rule, but a not normal circumstance is defined in case law, like the Humana case. It has to be some evidence that without approving the applicant, existing providers will be inaccessible or unavailable, or will suffer from overutilization, resulting in some quality of care problem. That's how it's been defined. There has never been a definition of a not normal circumstance simply being atypical and no problem associated with it. It may be atypical to be the highest quality provider in the nation. There's only one of those, but that wouldn't be a not normal circumstance. That doesn't rebut the need presumption. There has to be some harm being suffered or some problem in the surface area. Simply being a monopoly or the only provider by itself doesn't demonstrate some sort of unavailability of hospice services. It doesn't demonstrate that there is some access problem. That's where the special circumstance provision comes in. That's
Mr.
why
Frayne, excuse me for interrupting you, but you are into your rebuttal time. Feel free to use your time as you wish. I just wanted to advise you.
Your Honor, I will reserve the remainder of my time for rebuttal. Thank you.
Okay, thank you. Mr. Smith, you going first?
Yes, Your Honor.
So you want me to let you know when you're at 8 minutes so you can reserve 2 minutes for the final word on the cross appeal?
I would. Thank you very much, Your Honor.
Okay, I will do that. You may proceed.
Okay. May it please the court, Jeffrey Smith. Both as an appellant and a cross appellant and an appellee, we urge the court to affirm based on firmly embedded certificate of need principles that are embodied in case law decisions over the past 30 years. They're cited in our brief. There's the Balsam decision, the Johnson & Johnson decision, the Collier Medical decision, all taken together collectively. They established 3 bedrock principles that if you were to go and make a compendium of CON case law, go to the Division of Administrative Hearing website, pull up all the final orders, they all begin with 3 bedrock principles, and they're these. Number 1, the agency must conduct an evaluation and weigh and balance each of the statutory review criteria in every case. Number 2, there's no single criterion in statute or rule that is controlling. And number 3, the weight to be accorded to the criteria will vary case by case depending on the facts and circumstances. That is the fundamentals of certificate of need law in the state of Florida. It's been reiterated recently in the compassionate care case. So looking at those principles, what the judge did in this case is the judge looked at those principles and said, if I do that, if I weigh and balance all of the criteria, I find that it weighs heavily in favor of approving the certificate of need for continuum. Why? Because there's a monopoly provider. There's only one model of hospice care. He goes into great depth about the hospice house model of hospice care that causes this outmigration. It also skews the fixed need pool numbers. The judge in footnote 11 talks about how that double counting when people get moved from the Sarasota residence to the hospice house in Manatee and come back, it gets counted as double admissions, and it skews the numbers and makes it look like the numbers are reporting we've got 100% population service, which the judge said that's just not credible. It's skewing the data. So under the evaluation of extent of utilization, you can consider the fact that there is room for another provider. The fact is that we don't have to guess at the answer to the question, does the weighing and balancing of all the criteria support approval? The judge answered it for us directly in the recommended order, paragraph 109. It weighs heavily in favor because it provides people with a choice in their end of life care, a different model of care, and has benefits of promoting competition that'll foster quality and cost effectiveness. The compassionate care case, I won't go into great detail. I'm sure you'll have the chance, if you haven't already, to review that case. It's your sister court, the First District Court of Appeal, that looked at this issue in great detail. And going to Judge Lucas's question, they were looking at, you have really three sets of provisions that are operative here. You have the statutory review criteria in 408.035. There's 10 of them, only 8 of them apply in hospice, but those 10 criteria apply in all CON decisions. Then you have what are called special provisions in 408.0431, which Judge Lucas asked about, where they specifically state, the legislature makes clear their intent to discourage regional monopolies. And then you have the rule criteria in 59C-1.0355. And in that criteria, you have what's called the general provisions. And Mr. Frayne was asking, well, where is this not normal exception? It's right there. If you look at 3B, what 3B says in that rule is that in the absence of a numeric need under the numeric methodology, that you look at 3 sets. You look at the other rule criteria in this rule, which includes a whole bunch of things, but you look at all the other rule criteria, you look at the 408.035 general criteria, and you look at the special provision in 408.043. That is, to go to Judge Lucas's question, that's how the rule has a check in place to discourage regional monopolies, because it gives the applicant the opportunity to come in and say, we have a situation here that is atypical and not normal, which the judge found. And it does have an effect on competition. It does have an effect on people being able to choose a different model of care. So the compassionate case.
Mr. Smith?
Yes.
Can I interrupt you there, right there? So how do you reconcile 3B and 4D? I mean, is it your position that they are read totally separately, that they each provide different types of exceptions when you have a determination of no numeric need, as is suggested in the compassionate care case? Or how do you reconcile those two provisions?
I do think the compassionate care case did a good job at harmonizing those provisions. And the way I harmonize them so that to give each effect is to say that 3B follows the case law in Florida for 30 years. 3B is you can always weigh and balance all of the criteria. 4D does 2 things. Read the first sentence of 4D and it says, in the absence of numeric need, the applicant shall demonstrate circumstances. It doesn't place limits around it. Shall demonstrate circumstances to warrant approval of the application, period. Then it goes on in this next sentence to say, the applicant shall present evidence of at least to document one of the following, and it gives you 1, 2. And so putting it together, what you have is, yes, you get to weigh and balance everything. And in your application, you need to come forward with evidence to document one of these 2 things. And the applicant did. They presented evidence to document an underserviced African-American population. They presented evidence of the outmigration. They presented evidence of people who were dissatisfied or people who frankly had a negative experience with Tidewell, and then were left with no alternative if there's another family member. And that situation occurred in the testimony of several witnesses.
So your position would be that before you get to sort of like the whole enchilada in 3B, you've got to make this sort of threshold showing as dictated by 4D?
I don't think it's a 2-step process in terms of proof at trial. I think it's a requirement of your application to set forth evidence to document. Once you meet that threshold, once you've opened the gate and said, yes, I'm coming forward with evidence of that, now you can look at the entire body of evidence and say, does it weigh in favor of approval or not, including your evidence of the special circumstance population. But it's not a 2-step, oh, you cannot pass go if the judge says, I don't find that you prove this element, therefore all other, because what that does is that would say this one criterion controls over everything else.
Oh, I
agree. That's exactly what the Balsam and Johnson cases were saying. You can't do that. The agency does not have the inherent power to enact a rule that says, if you don't do X, then you can't ever get approved, because the legislature has said you must weigh and balance all of these criteria in each case.
But
Mr.
if you
Smith,
turn the way-
excuse me, you're at your 8 minutes, so use your time as you wish.
Okay, let me just check real quickly. I'll just end by saying I think the importance of competition and choice for patients at the most critical time, perhaps in their family's loved one's life, is so critically important. And one last point, I need to mention that there is an adequate network standard. One of those statutory criteria is Medicaid and service to the Medicaid population. And there is an adequate network standard established by the agency in its model contracts that sets it out in black and white. The requirement to have an adequate network for managed Medicaid providers is 2 per county. That's black and white, and that's so that Medicaid recipients have a choice in end-of-life care, just like all other people who are having Medicare pay for their service, or any other payer paying for their service. Thank you very much. I'll reserve the
Thank you,
remaining.
Mr. Smith. I'll get you 2 minutes on the rebuttal and the cross appeal. Ms. George, you ready to go? Do you want 2 minutes, or are you going to use your whole 10 for your?
I'm going to use my whole 10, Your Honor.
Okay, very well. You may proceed.
May it please the court, my name is Tracy George, and I represent the Agency for Healthcare Administration, or AHCA, in this case. But it sounds to me like this court has some questions about the structure of the CON law, so I'm going to start with that. The way that we read our rule is that 3B is the formula on which the certificate of need is based, right? It includes consideration of all the review criteria, including the need criteria. The need criteria are set forth at paragraph 4 of that rule and include the numeric need formula at 4A. And there's 2 not normal circumstances at B and C. And then that subsection D, the 2 special circumstances. You do have to have one of the 2 special circumstances shown in order to get a CON, we believe, because need is very, very important. You do need to establish need, but we can consider other not normal circumstances in that need calculation, both under 3B and we believe under 4D. So that's how we read our rule. And when you're talking about the issue of monopolies and competition and such, there's 2 places where we can consider those. There's 408.035 subsection 7, which talks about the extent to which the proposal will foster competition that promotes quality and cost effectiveness. And then there's also 408.043, which talks about the first sentence of that says that the formula on which the numeric need must be based on the availability of hospice services in the community. That's separate from the formula on which the certificate of need is based, which is the formula we believe for the entire determination, the whole weighing and balancing.
So 59C.103554 is not the numeric formula for determining certificate of need?
Subsection 3B is. 4A is the numeric need, okay?
Yeah.
4A is
It seems to me that your reading, the agency's reading, has relegated the statutory directive to include that in the formula as something that can be considered to the overall determination in response to what you would call a rebuttable presumption. And I'm not sure that's what the legislature directed, but we have to work with what you all have in place. And that's what I'm struggling with to do in light of what the statute said to do with the numeric formula that I don't read in the numeric formula, but now what you're telling me is, well, we do consider it as to whether or not it rebuts a presumption or not. I'm not sure that aligns with what the legislature directed. But now we got to figure out what to do with it.
Let me see if I can clarify. Okay, sure. When you read 408.0431, it says when an application is made for a CON to establish a hospice, The need for such hospice shall be determined on the basis of need for and availability of hospice services in the community. All that's saying is that we do have to have need considered. There's another subsection, or another statutory section that says we do have to have a numeric need formula. But the next part says a formula on which the certificate of need is based, not numeric need, the certificate of need is based shall discourage regional monopolies and promote competition. So we can always consider that in the weighing and the balancing. Now we can also
But the
consider.
statute says formula, not the determination. I mean, that you just breezed past the word formula there.
Your Honor, a formula doesn't have to be a numeric formula. It can be the decision-making process. If you look at the definition of formula in a dictionary, it doesn't have to be a new mathematical formula. It's a way, it can be a weighing and balancing as we use it here.
Mhm.
Now, in this case, whether Tidewell is a monopoly or a regional monopoly, it doesn't really matter, as both are not normal.
Ms. George, may I, a couple of clarifying points on the monopoly issue. You're not going to have price competition because Medicare is going to pay whatever Medicare is going to pay, correct?
Yes, Your Honor, or Medicaid or any other
Medicaid, yeah.
payer.
And I recall the ALJ made a finding that to the extent the delivered product will improve, that it would be at best marginal with a
Yes,
second
Your Honor.
provider. Is that right?
That is correct, Your Honor.
Okay.
I'm
I'm trying to understand how those two findings impact the competition analysis.
Okay, the competition analysis, what the agency did was we looked at what the ALJ found, right? The ALJ found that he thought that the monopoly weighed heavily in favor of the granting the CON application, okay? And so the agency didn't disagree with that. That was a conclusion of law that was within our substantive jurisdiction. We agreed with it. And so the way that this works is that as long as the agency's decision is not arbitrary and capricious, and it's compliant with the CON law, then the court should affirm. They talked about that a great deal in compassionate care hospice. So this court doesn't have to figure out what weight to give it. The agency's already done that. The ALJ's already done that. So what this court does need to look at is whether or not there was a special circumstance in this case. The agency found that there was, that the outmigration rate of 35.8% residents leaving the county for hospice house services is gigantic. That's nearly 40% of people who need hospice house services have to go outside the county to get it. Now, the Certificate of Need program is predicated on the idea that service areas and sub-districts are going to be self-sufficient, self-contained. So you're supposed to be providing all the services that residents need inside the county. Tidewell's got this unique situation because they have the 3 contiguous service areas for contiguous counties. So what Tidewell seems to be doing is when its hospice house beds are full, which is most of the time because the record of evidence established that they were at capacity at 94% of the time. So what they're doing is they're trying to keep the money in the family and send these people outside the service area. That's not appropriate, right? So anytime you have a high outmigration issue like this is going to be an access problem. This is going to be a lack of service problem. And that's what the agency found in this case.
But the ALJ made a factual finding that outmigration was soon to be remedied. Is that correct?
Yes, Your Honor, but the rule, the actual rules is looking at what the current situation is. And the agency is not convinced that it's going to be
I had a question. I actually had a question about that. How do you interpret that? I've not seen that kind of thing where in an administrative ruling where it looks like this is going to get taken care. I mean, is that a factual finding? Is it, and then, kind of an expressed hope? What is it?
Your Honor, we're not really sure either. We don't,
Okay.
not very convincing. We're talking about a hospice house problem And somehow that's going to be solved by putting in inpatient units in a hospital and in a nursing home. If the preference is for hospice house services, that's not going to solve the problem. They've already got scatter beds available in the various hospitals. So, you know, the ALJ did find that he thought it was about to be about the access problem was about to be remedied, but he did implicitly in doing that find that there was an access problem. Right? If there's 34.5% or 35.8% of people are leaving the county to get a service, they're not getting services in the county, which means that they and their families are having to leave their residences, leave their homes, and travel somewhere outside the county, outside the service area to get a service. And this is problematic. Now, obviously, Continuum's service model is more based on a providing more services in the home versus Tidewell seems to take people out of the home and put them in hospice houses. So this is another reason why ACA thinks that this is a good solution here, to have a second choice, second idea of where you can go and how to solve the problem of the hospice houses. Now, both the ALJ and ACA agreed that there were several not normal circumstances in addition to the monopolies. There were the Medicaid contracts. There was the noise and distortion in data because of the outmigration. So there was that. The agency followed 120.571L when it made the changes to the recommended order paragraphs 109, 110, and 119. We found that the conclusions of law were within our substantive jurisdiction. We found our conclusions of law were as or more reasonable than the ALJ's, and we stated our reasons for modifying, which were generally the 35.8% outmigration rate.
Boy, Ms. George, you're just approaching your 10 minutes.
Okay. I'd like to conclude by just reminding this court that in compassionate care hospice, the court considered all of these same things and basically said that the takeaway from the CON law is that the agency has a great deal of discretion, has much play in the joint. The court's constrained to decide whether ACA acted within its rights. And because the record showed that there's a balanced consideration of all relevant criteria in this case, and ACA's stated basis for rejecting the Continuum's application, or in this case, granting Continuum's application was plausible, it should affirm. Thank you. The agency rests on its brief.
Thank you, Ms. George. Mr. Frame.
Thank you, Your Honor. Let me address some of those as quickly as I can. Your Honor, the agency doesn't look at the current situation and evaluating need and evaluating circumstances. The whole need formula, in fact, projects forward what will be the need in the future in the planning horizon. The planning horizon is supposed to be when the applicant is supposed to be licensed and operational. So that's what you're evaluating. You don't evaluate just the current circumstances, you look forward. As to this hospice house outmigration issue, the total outmigration was a little over 2,000 patient days. And just to put that in perspective, Tidewell delivered over 200,000 patient days in Sarasota County. So the outmigration is really equivalent to about 1% of the patient days that Tidewell delivered in the county. Maybe more importantly, hospice houses are a separate regulated service. You need a separate CON to establish a hospice house. If the argument is that Tidewell does not have enough hospice houses, then you need to apply for a hospice house and demonstrate that as the need. The outmigration doesn't show the need for a new hospice. If anything, it would show that more hospice houses would need to be built. And in fact, the judge found that Tidewell is building more hospice houses, and that will resolve the outmigration for that service, which is not the service this applicant is applying for. In fact, the applicant has committed not to build hospice houses. One thing that I would like to point out that I think bears emphasis is that there is a fixed need pool rule in this case. It's Rule 59C-1.008. And in paragraph 2 D is one I want to direct the court's attention to. The fixed need pool rule was established as a rule that directs the agencies to publish what the need is, so that everybody knows what the need is and can compete for that need. And part of that rule says the agency will follow these procedures when awarding beds or services identified in a fixed need pool. So this is what every potential applicant is told. It says in D3, if a qualified applicant exists, but the proposed project exceeds the better services identified in the fixed need pool, which is the circumstance here, the agency may award beds or services in excess of the pool when warranted by special circumstances as defined in the applicable section of 59C-1 for the particular type of bed or service. So what this rule is saying, if you want to award in excess of the fixed need pool that's established and that is published, then you need to look to how special circumstances is defined in the applicable rule. That's the rule we're talking about here, where the applicant failed to demonstrate the special circumstance. So this is what every applicant is aware of. And if you have one applicant who ignores this and says, okay, I'm going to apply, I don't have special circumstances, but I'm going to get in the gate and the agency is going to ignore this rule and approve me, that's why you don't have anybody else in this case competing, because everybody else read this rule and the agency's other rule and assumed only under special circumstances as defined in that rule would anybody be approved. Your Honor, you did ask a question about reconciling the interpretation of 3B in the hospice rule, and let me address that real quickly. The key is it uses the word and instead of or in that provision. It says applications to establish a new hospice program should not be approved in the absence of need indicated by the formula unless the other criteria in this rule, which would include 4D and in 408.035 and 408.0431 outweigh the lack of numeric need. So as a first step, you gotta meet the rule criteria. You gotta meet the special circumstances, and you have to meet the statute. So it's a necessary condition to show a special circumstance, but it's not sufficient. You also have to address the statutory criteria. Now, on the issue of rebutting need, do you need to consider all the statutory criteria is the issue. I contend, Your Honors, that you have to address all the relevant criteria when you're rebutting need, but not all the criteria are relevant to rebutting need. And let me give you an example. The financial feasibility of the proposed project, that's not relevant to rebutting need. That's not whether there is currently a need in the service area. So that would be a criteria that would not be relevant to rebutting need. The means of construction, that is one of the statutory criteria, that's not relevant to rebutting need. The only criteria that are relevant to rebutting need are the ones dealing with in paragraph 2 of 408.035 that concerns the availability and accessibility of the existing providers. That's what the special circumstance addresses. The special circumstance provision takes into account the criteria that are relevant to need because it looks at are existing providers available and accessible. If they are not available and accessible, then you have a situation where you have a population not being served. You have a county not being served. So the special circumstances provision is directly tied to the statutory criteria. You're not ignoring them. The special circumstances provision is intended to implement the criteria that are relevant to the issue of need.
Mr. Frayne, you're going to have to wrap it up, please.
Okay, Your Honor, I understand. I believe I am out of time, and I do appreciate the court's time. And if the court has no other questions, then I will conclude.
Thank you very much, sir. Mr. Smith, you want to say anything on the last word on the cross appeal?
Yes, Your Honor, there was a question that I believe you raised regarding how quality the quality factor would be evaluated. You said marginal. The judge made a thing about there could be a marginal increase. Judge was talking about specifically, if you read that paragraph, about complaints, and that it would bring Tidewell to be more attuned to not having those types of complaints. But what the judge also found with respect to competition very clearly and throughout the order is that it is a different model of care. And this is what the healthcare economists talked about, quality across the spectrum, by offering a different model of care that provides a different way of caring for people at end of life instead of moving to a hospice house, which went to the issue also of competition with respect to price, because the general inpatient level of care, it's in the order, is the highest reimbursement rate compared to being able to care for people in their home, which is a lower reimbursement rate. So it has an effect on cost effectiveness. Last thing, there was a question raised, and Mr. Frayne said, well, no other applicant would know. The 59C-1.008 has a triggering mechanism. It's called a grace period letter of intent. It's contained in the rule. Anytime anybody applies, whether they apply under a numeric calculation or under not normal circumstance or special circumstance, it triggers a grace period and allows other competing applicants to say, somebody's applying, I think I'll apply as well. Last point would be on the numeric calculation. I just want to say the numeric calculation is not what the agency publishes yes or no for need. One, it's either 1 or 0. That's the way they publish, but the formula doesn't result in that. The formula simply gives you a future projected number of hospice admissions. And if it's above 350, they say yes, need. If it's below 350, they say no need. And what the judge in this case found is that that data was being distorted and skewed, and it was making that factor, when I weigh it all and balance it together, that factor gets less weight because it's skewed. The data is not reliable to that calculation. Otherwise, you may never see a need because they're counting people twice. So I'd leave it there, Your Honor, but I think for the reasons we've stated and for the reasons stated in our brief, we urge the court to affirm.
Thank you very much. Mr. Frayne, Mr. Smith, Ms. George, thank you for a well-argued presentation. That concludes our docket, and we are adjourned.
Thank you, Your Honor.
Thank you.
Yeah.